keynote speaker is next, Dr. Shawn Wygant. Dr. Wynant is a highly skilled forensic psychologist and child custody evaluator and trainer who specializes in the assessment and treatment of parental alienation and other complex forms of psychological child abuse. He shares his expertise with family courts across the country, assisting triers of the fact in unpacking complicated behavioral science evidence. He works tirelessly to put essential research concerning parental alienation into the hands of family law professionals, mental health workers, and targeted parents through ongoing training seminars. Shawn has dedicated his professional work through his company, psychlaw.net, to the training necessary for family law judges to understand how to intervene in cases of parental alienation.
Good morning, folks. I'm glad to be here. Okay, great. Well, how did we get here? Well, all of us are here because at some point or another, parental alienation has touched our lives. And the main reason we're here is to shout out to the world that parental alienation is a form of child abuse. And it's important for us to get that message out through training, ongoing training for legal professionals and mental health professionals. So today's presentation, I'm going to walk us through some of the cases that have been going on with parental alienation in my state of Michigan, as well as the 370 parental alienation cases that I've personally worked on as an evaluator since 2013 that covers a 10-year span. And then also get into some of the science that I think is important for us to understand and carry forward in whatever capacity that we have, whether we're working in this family court system as an advocate for a child or a legal advocate for a parent or an attorney or a mental health professional. So how did I get here? Well, I'm an alienated father. I didn't know about the concept of parental alienation until my first daughter was born. That was back in 1989. And then when I was, her mother refused me contact and I went to various court hearings, I kept hearing the same kind of refrain that all kinds of irrational, frivolous excuses why the mother and her new boyfriend, fiance, did not want me to have any contact with my daughter. And this went on and on and on. And even after dozens and dozens of hearings, evidentiary hearings, the court still, even though the court understood what was going on, really didn't take the concerted action necessary to prevent my daughter from becoming alienated. So that's why I'm here. And of course, I'm talking about my oldest daughter, who's in the center of that picture. Her name's Cassandra. So who needs parental alienation training? Well, first of all, judges. Second of all, attorneys representing parents in conflict. Third, child legal representatives, and these would be lawyer, guardian ad litems, and also lawyers who act in the role of guardian ad litem, which are two distinct roles, mostly circumscribed by statute. Mental health workers, this would include therapists and evaluators, custody evaluators in particular. Child protection workers and forensic interviewers, because as we know, when parental alienation is involved, it's not uncommon for child protection services to be called and to investigate, and then the children end up being interviewed by forensic interviewers. And lastly, legislators. Those are the people and the folks that we need to put the science in their hands so they can enact laws to protect children from parental alienation, child abuse. So why judges? Well, in our jurisprudence in America, which we inherited from England, we honor, for good or bad, the concept of parens patri, which is the parent of the country. It's Latin. So most parents, when they go into the divorce process, they don't understand that children are become wards of the court and wards of the state until they're adults. Because of the final decision-making powers, the parens patri is rests in judicial officers. So in terms of the hierarchical structure, we're looking at judges at the top, and of course any judges or magistrates that serve under them, which in my state would be friend of the court referees. And of course, under that authority would be the parents, and of course, lastly, the children. So next, we want to look at why attorneys and child legal representatives need to be trained in parental alienation, child abuse. First of all, lawyers, by their own professional codes of conduct, take on an advocacy role, and they are in a position to zealously represent their clients' interests under their professional rules of conduct, which is one, competence. And competence means they have to know the law, and they also have to know the scientific behavioral science issues that are related to their case. So they have an ethical obligation under their rules of professional conduct to know the science. They may not say so, but there is an ethical obligation for them to know the science and the law. And it's important for us to know that so that we can hold them accountable when they take on cases that they're clearly incompetent to handle. So competency just does not rest in the mental health profession, but also we have to require it of our legal professionals who either represent us or represent someone on the other side of the aisle. Another really important professional rule of conduct is candor to a tribunal, and that's Rule 303. And this is important because when a lawyer is apprised of something that they've said or written in a pleading that is demonstrably false, they're required to make that known to the court and correct the error. Otherwise, they're responsible for violating this rule, which is to be candid and truthful with the tribunal, which refers to trial courts or any court, because they're an officer of the court. So why do I bring that up? Well, I bring it up so we can understand that we have an obligation. If we know that parental alienation is a form of child abuse, we need to bring it to the attention of the lawyers, all the lawyers that are in a case, and make sure that we're holding their feet to the fire. In whatever ways, if we have to help them and shepherd them into the science and say, here, because I can remember being in a hearing, and then one of the very first books I read, which wasn't called Parental Alienation, but dealing with children held hostage by Dr. Stanley Claywar and Brian Rivlin. And I remember handing that to one of the attorneys. And even if it goes, he basically threw it in the recycle bin. But I did my part. And I think we have that duty to ourselves, and especially to the children, and to honor the court and the rules of telling the truth. This is another important rule that we need to know about: fairness to opposing party and counsel. A lot of people don't know that, but lawyers are supposed to be fair to opposing counsel and opposing parties. They're not supposed to get into a blood sport. They're not supposed to walk into court and malign the other parent or say things that aren't true or throw mud against the wall and then say, to the best of my knowledge and belief. To the best of my belief and knowledge, which is another way of saying, I may be lying, but it doesn't matter because I can get away with it. So I may sound a little cynical, but I think it's important when we get into these really terrible, terrible cases of parental alienation, child abuse, you're going to uncover, and I testify a lot, and I find that some lawyers are absolutely wonderful people and they follow this rule, but a lot of lawyers don't. And a lot of them end up in these parental alienation cases. And they're the ones that usually deny that parental alienation, child abuse, doesn't exist. So the other thing, they need to know about triangulation and third-party alienation. What does that refer to? As Rod was telling us, triangulation is when a third-party triangulation is when you adopt and take sides with somebody against another person, knowing that the side you're on is unjustifiably vilifying the other party, who becomes the scapegoat in a triangulated process, what we would call perverse family drama triangle. which we're going to go over in a little bit. So why do we want to train mental health workers? Well, therapists. Therapists are in almost every case, high conflict parental alienation case I've ever been involved in. This is a very standard way that family courts delegate conflict. Send the child to a therapist. It doesn't work. It's not the child's problem. You have a problem in the family system, and the family may need family therapy, but when you have an alienating parent and a targeted parent, the alienating parent 9 times out of 10 is going to be very resistant to engaging in any blame sharing. So what do they need to know? They need to know the pitfalls of court-involved therapy with families in conflict, triangulation. They need to know how to recognize signs of parental alienation, child abuse, and make clinical assessments of parental alienation behaviors. They need to document it in their progress notes, or parental alienation symptoms noted in their therapy records. They need to know the ethical guidelines and codes of conduct so that they stay within their lane. They stay within their role as a treatment provider and not an evaluator to make recommendations for parenting time or custody. They need to know, most importantly, when to decline, terminate, or refer out. Why? Because it has to do with competency and progress. There is an ethical code in the APA, which is the American Psychological Association Code of Ethics, in the section 10, that says if therapy is not progressing and there's no chance that it's progressing or it's getting worse, they have an ethical obligation to terminate the therapy or refer it out. And with respect to declining, that is in terms of knowing the therapist needs to know when they're getting in over their heads and they don't understand some of the problems that are inherent with child abuse. If they're not competent in that area to make clinical assessments, they shouldn't take on the case. They need to know how and when to consult with attorneys and other professionals. Evaluators. So this has to do primarily with custody evaluators. Anybody who's called in any of the jurisdictions across the country to be fair and neutral, to be competent, to know the science and relevant law with respect to psychological maltreatment and parental alienation. And this would include understanding the best interest of the child and how to do a best interest of the child factorial analysis with respect to parental alienation and how parental alienation as child abuse factors into all of the various best interests of the child factors. For example, in my state, we have factor J of the best interest, and that's the willingness and capacity to facilitate and encourage a close and continuing relationship between the child and the other parent. So the evaluator has to know that if there's one parent who's not facilitating the relationship and not willing to, and is engaging in parental alienation behaviors by limiting contact, by confiding in the child. And that is a factor that they need to integrate and cite to the relevant science. And based on hypothesis testing, in other words, looking for all the evidence that says something's there and looking for all the evidence that says it's not there. And then if it is there or if it isn't, how are you going to weigh its effect? And so that all has to do, when we say factorial analysis, it's the weighing of evidence in which way it preponderates, and in combination with other pieces of evidence. And when you have two parents who are acting in different ways, you have to put all that together. So that has to do with competency. And the last one of those, write reports that capture the full picture. So don't leave anything on the table. I frequently brought in to look at other custody evaluators' works. And one of the things I frequently find when it's a very, very high conflict case and there's allegations of sexual abuse, the custody evaluator doesn't talk about it. And I even went to a seminar recently and asked, and the person conducting the seminar said, you don't evaluate sexual abuse. You just let CPS determine it and then report that to the court. And that isn't true. That's not accurate. When you're asked a referral question from a court and there's allegations of, let's say, sexual abuse or allegations of domestic violence or allegations of any kind of abuse, you're supposed to evaluate the family for what it is the court is asking you to do. So when you get a report back and it doesn't capture the full picture, we need to train evaluators how to do that. So why CPS workers and forensic interviewers? Because CPS workers are paid to protect children, and most of them want to protect children. That's why they're there. So we need to help them. And I've been really successful in my area, in my particular geographic area, because they seem eager to learn and understand parental alienation as a form of child abuse. So they need to know the pitfalls of investigating child abuse and neglect in general, when parents are in conflict, and specifically alienation processes. They need to know how to recognize signs of psychological maltreatment and parental alienation, because parental alienation is a form of psychological maltreatment, and how to rule in or out these forms of child abuse during their investigations. Forensic interviewers need to have a certain level of competence. They need to know what the science says about the effects of psychological abuse, parental alienation, child abuse on the child's ability to recognize reality and talk about their experiences versus the experiences of the alienating parent. That's really difficult, because we know when we see an alienated child who's brainwashed, one of the signs is borrowed scenarios. So how do we know, or independent thinker phenomenon? So how do we know the child is speaking from their own personal knowledge base of what they've experienced? Or how do we, versus just repeating things that they've learned from their parent? Most of the times we don't talk about these things with forensic interviewers. They kind of live in their own world and they go to their own training seminars, but as this is related to child abuse. So it's important for forensic interviewers to understand the dynamics of brainwashing, because that's really at the heart of the kinds of kids that they are interviewing. Sometimes, not always, but sometimes. So legislators, why legislators? Why do we need to train them? They write the laws that circumscribe how judges can interpret evidence or fashion remedies, i.e. Caden's Law and Peaky's Law. They create statutory definitions for what constitutes abuse of a child. They make findings about science issues based on input from the loudest voices in the mental health and legal communities. So they need to know how psychological maltreatment and parental alienation child abuse should be defined in the law, and how parental alienation child abuse statutes in other jurisdictions, such as Brazil, have reduced parental alienation child abuse. So in my state, we have something called serious mental harm. This is a child abuse definition. An injury to a child's mental condition, not necessarily permanent, but results in a substantial disorder of thought or mood, which significantly impairs judgment, behavior, capacity to recognize reality, and the ability to cope with the ordinary demands of life. Those are some of the things we see in severely alienated children. But hold on. So second-degree child abuse is when a parent knowingly or intentionally commits an act likely to cause serious mental harm, regardless if harm results. It's important that you understand that concept, because that's the theme of this presentation. We don't wait till a child is exhibiting symptoms of parental alienation before we identify it as parental alienation, child abuse, and report it as such. So why legislators? Caden's Law. Here's a good example of how the legislators heard a bunch of junk science where it conflated acts, real acts of coercive controlling violence and murder against children and mothers with false claims of parental alienation. So in Caden's father, Jeffrey Mancuso, never made a claim of parental alienation. It wasn't in the case. Caden's Law provides federal grants to states that pass laws requiring courts in child custody proceedings to view remedies for protecting children from potential from parental alienation, child abuse, as harmful. It reframes parental alienation as part of a resist-refuse dynamic. At least that's the trickle-down effect. Through the lens of resist-refuse dynamic, the spectrum of parental alienation disappears and is replaced with the idea that when a child resists contact after a family is legally dissolved, it is assumed that the target parent co-created the symptoms in the child. This assumption creates a confirmatory bias where parental alienation is either not considered or ruled out per se. So it's kind of a washing out of the construct within the resist-refuse dynamic. People who promote that theory of putting parental alienation syndrome or symptoms in that box. So let's take a look at the case of Mancuso. So this is 7-year-old Caden Mancuso was murdered by her father in a murder-suicide. Jeff had violent past, including charges of aggravated assault. The mother, Kathy Sherlock, described the violence she suffered. Quote, "The only time I felt safe, felt I was going to die, was in the clutches of his arms when he was strangling me." Court gave her custody and ordered supervised visits for Jeff. No parental alienation, even though the court evaluator reported Jeff suffered from MDD, major depressive disorder, and narcissistic and antisocial personality traits. No claim of parental alienation, and the court did the wrong thing. They took a violent guy, and he ended up killing his daughter and killing himself. So here's a little excerpt from that.
Caden, look up here. Give me a smile.
Fight song seemed to be Caden Mancuso's personal anthem.
I might only have one match, but I can make an explosion.
Everyone thinks that their kid's the most amazing person on the planet, but this little girl was different. She was special. Everyone wanted to be her best friend.
But at 7 years old, that bright light faded. Her vibrant life cut short in a flash.
I still don't feel like it's real. I still feel like I'm going to wake up from this awful nightmare, and but I know that I'm not.
That nightmare, an unimaginable murder in the wake of a raging custody battle. Caden killed by her own biological father, Jeffrey Mancuso, in a murder-suicide. Now, just 1 month after her murder, Caden's mom and stepdad, Kathy and Brian Sherlock, speaking out against a family court system they say failed Caden by not properly taking into account Jeffrey's violent history and what Kathy says were her repeated cries for help.
Do you feel like your daughter's death was preventable?
Absolutely. Oh my God,
100%.
absolutely. By every single thing that could have stopped it at some point, it just didn't.
Yay! With 3 beautiful kids and a new puppy, the Sherlocks thought life couldn't get any better. But there was somebody else in the picture, Caden's biological father, Jeffrey Mancuso, whom Kathy met one summer on the Jersey Shore.
It was a fling.
Yeah, basically.
They never married, but they moved in together when Kathy found out she was pregnant.
I thought that that's what I had to do, to try for Caden to give her 2 parents.
Despite the chill between mom and dad, Jeffrey's sister Allison says the father-daughter bond was strong.
She would always say how, she loved him. My brother is 5'6", and she would say things like, "My daddy's so tall." She just thought he was so tall and so strong.
Hi, I'm Caden.
Caden was one of the only bright spots in his life, which his sister says was troubled since childhood. Issues made worse, she says, by drinking, self-medicating, and violent outbursts.
He's punching teachers, getting hit in the head with a pool stick. He had like 17 staples in his head or something like that.
How much did he drink?
If I would go out to have a beer with him and I would be on my 2nd beer, he'd be on his 13th beer. It was that kind of drinking. Between the drinking and the hits to the head, he suffered from some brain damage, which caused him to...
Okay, I don't think we have time to go through the whole thing. You can see that you have a psychologically disturbed father, no allegations of parental alienation, but this is the case, and we do need to protect and do things to train judges. One of the reasons why we need to train judges, not only on parental alienation, but how to do evaluations, independent evaluations. A court Ultimately, a judge is responsible even if they get bad information from mental health professionals. They like it or not, they have the ultimate responsibility to make sure that kids are safe, and that if you have a violent, aggressive, psychologically disturbed, homicidal parent, suicidal parent like Jeffrey Mancuso, you don't let him have contact with his daughter. But this has nothing to do with parental alienation, and unfortunately, this law is being conflated with that. So here's another case. I won't play the video excerpt. Another instance of a father, and these are cases that are frequently cited. 7-year-old Charlie and his brother Braden were murdered by their father, Josh Powell. The boy's mother, Susan Powell, disappeared and her body was never found. The boy said, quote, "Mommy's in the trunk," unquote. Authorities believe Josh murdered Susan and drove around the body in the car with the boys when they went on a surprise midnight camping trip. No claim of parental alienation. So, of course, these are in the context of custody disputes and visitation, but it shouldn't be conflated with parental alienation, child abuse. So let's take a look at a Texas case here. You probably are familiar with this. This is the case of Eric Lostro. And his mother, Deb Geisler, falsely accused the father, Dr. Rick Lostro, of sexually abusing their son Eric as a tactic to gain sole custody. Child Protective Services, law enforcement conducted numerous investigations to determine the allegations were false, unfounded. Mother engaged the boys in sexual abuse therapy with the help of a psychologist, convinced Eric that he was sexually abused by his father. So here's an excerpt from MSNBC, Nightmare Behind Closed Doors. A mother pushes her son to murder. The mom used the kids to hurt the father. Quote, "Dad never loved you. Dad didn't ever want you."
He used the kids to hurt him.
Called him up, put the phone down, and then told the children, "Dad never loved you. Dad didn't ever want you."
She's telling the children this
while he's on the phone
and he can't do anything
and he can't do anything about it.
And they say Deborah was violent too.
She threatened to inject him with insulin while he was sleeping.
Deborah was arrested and jailed for that threat, but always maintained it was a joke and was never convicted of anything. As for Deborah's most serious allegation that Rick sexually abused his older son, his friends and his divorce attorney Kathleen Collins say it's outrageous.
It is the most ridiculous, baseless, groundless accusation that I have ever heard. And the only person that believes it is Deborah Geisler.
Rick always denied the allegations of sexual abuse, and no charges were ever filed. Rick even passed 2 polygraph tests. Rick's friends say Deborah concocted the story, convinced her son to believe it, and then shopped the allegations to 4 different law enforcement agencies. And they say even when the charges were not substantiated, Deborah threatened to pursue them anyway.
So let's move on. So here's the prosecutors. And so Eric, one afternoon, let me move my thing here. It's in the way. One afternoon after the father came to pick up the children for parenting time, the mother, Deb Geisler, gave Eric a 20 milligram dose of Prozac and left a loaded .40 caliber Glock pistol accessible to Eric. Earlier that day, Eric had been told by his mother and a therapist that his father had also sexually abused his younger brother. When the father arrived to pick up the boys, Eric grabbed his mother's loaded gun and walked out to his father's car, got in the back seat, and shot his dad 3 times in the back. And the younger brother testified that Eric gave his mother the okay sign after killing his father, and also wrote in a school paper that he, quote, heard his mother tell his brother to shoot his dad, unquote. Here's an excerpt from the television coverage where the prosecutors describe this.
And there was something else. A school paper the younger child later wrote about the day his dad died.
The assignment was to write about a day you were afraid, and he wrote about the day that his father died. He wrote that he heard his mother tell his brother to shoot his dad.
So what does it have to do? What does this have to do with parental alienation? Here's why. Here's the prosecutors talking again Why did Eric kill his father? And let's hear what they have to say.
Why did this boy kill his dad?
The short answer is because he was angry. The simple answer is that he had become so alienated from his dad, and he, in his mind, Dad was really the source of all of his problems. And if you eliminated Dad, you eliminated the problem.
Do you think Deb Geisler played a role in this?
There's no question that she created the poisonous environment that led that boy to shoot his father.
And I always, felt like if she didn't put the gun in his hand, she at least put the thought in his head.
Okay, so sadly, this case initially could be instructive to let us know what went wrong in a very hostile, volatile case with all kinds of false allegations. Unfortunately, if you go back and read the Court of Appeals case, the justices say, well, the sex abuse could have happened, and they sort of excuse the behavior without shining a light on what this case really tells us, which is that some alienating parents do this to kids, and it's alienation, child abuse, not just simply false allegations of abuse. So let's take a look at some of the literature and what the literature says currently. This is from a published peer-reviewed study by Saini et al., published in the Family Court Review. And, quote, parental alienation behavior therefore includes making repeated unfounded allegations of child abuse, which pose a risk to the child, as the child is required to undergo repeated investigations or may come to really believe the unfounded allegations to be real, unquote. So we see here what Rod talked about earlier. This is a perverse family drama triangle. And of course, when it's not recognized, we don't realize what's happening. When an alienating parent is unable to accept responsibility and normal blame sharing, in other words, something's part my fault and it's part the other parent's fault, they engage in really what we call rigid perverse family drama triangle, where they become enmeshed with the alienated child, which they claim is a victim of the targeted parent. And then they gather up with false narrative scripts, all kinds of rescuers. And this could be a therapist, it could be a guardian ad litem, could be a CPS worker, a police officer, a medical doctor, custody evaluator, magistrate, and judge. And of course, that becomes, and these symbols here are, emotionally cut off. That's what those symbolize. So you have cut off and, of course, the destruction of parent-child relationship. So these are in extreme cases. So it's important to let, this is why we want to train professionals. So let's look at the scope of the problem. One of the problems and barriers we have to identification is, how do we frame parental alienation? It's a form of child abuse, but is that acknowledged anywhere? It's acknowledged in the literature, but is it acknowledged in the law? Well, some statutes. So let's take a look at what the literature says. So this is the latest handbook on child maltreatment, published in 2022. Hart et al. Say, quote, psychological maltreatment occurs within social interactions. It's expressed in various forms of abuse and neglect, which limit, corrupt, distort, and damage the child's development, functioning, relationships, and health, unquote. And Edward Crook, in 2018, published his treatise, and quote, parental alienation is a significant form of harm to children that's attributable to human action. As a form of individual child abuse, parental alienation calls for a child protection response. As a form of collective abuse, parental alienation warrants fundamental reform of the family law system. This is an incredible insight into his years of seeing these cases and understanding them. This is the cumulative literature speaking loud and clear that it calls for a child protection response, no matter where the case lives. If it doesn't live in a dependency or neglect abuse case or a criminal case, and it lives in a family court case, it's still child abuse, and it calls for a child protection response by the judge. So, what did Gardner say? Richard Gardner said, inducing parental alienation syndrome, which is the symptoms, he identified 8 of them, in a child is a form of child abuse, more specifically emotional abuse. That's what he said. So the Brazilian law passed in 2010 was just amended in 2022 or 23, I think. Quote, an act of parental alienation is deemed the interference in a child's or adolescent's psychological education promoted or induced by either parent, by grandparents, or by those who hold the child or adolescent under their authority, to reject one of the parents or that hampers building or maintaining bonds with them. Now that's a translation, so it may not be completely accurate, but it's pretty solid. This is a template. You cut and paste it, modify it, give it to your legislators, and tie it and key it in whatever jurisdiction you live in. Look up in the legislature code of laws how they define emotional abuse, and make sure you get the science out and you can help amend that law to include this kind of a law so that parental alienation makes it in as a form of child abuse, just like it is here. So that's why I included it, so you know it, and I can send you all the links to all this literature that I'm describing. So the DSM-5, of course, in 2013 included in the back section child psychological abuse. And the only reason I'm referencing this here because it goes along with our theme today of understanding that you can have non-accidental verbal or symbol acts by a child's parent, which includes parental alienation behaviors, that result or have reasonable potential to result in significant psychological harm. And of course, if it has reasonable potential to result, regardless if it actually does result in harm, we still call it child abuse. And that's why this is important to understand, because that's how the spectrum of parental alienation lives in the science and the law. So we're dealing with two variables: exposure, evidence of parental alienation behaviors that are likely to cause psychological harm, and impact, evidence of parental alienation behaviors that have already caused psychological harm, i.e. parental alienation syndrome or symptoms, however you want to refer to it. So I want to briefly talk about prevalence so you have these numbers. So when you are talking with legislators or judges or lawyers or mental health professionals, you're armed with data. So in 2021, we look at the reports for abuse, all forms of abuse, and look at what happened to psychological maltreatment. 6.4% of 588,229 cases of substantiated victims of child abuse and neglect, only 6% are psychological maltreatment. What does that tell us? It's underreported, but why? So let's take a look. Stoltenberg et al. In 2021 came out with a study. This was a comprehensive meta-analysis, combined prevalence rates, figures of child emotional abuse reported in 29 studies with a total of 7 million participants. Estimated prevalence was 363 per thousand for studies using self-report measures. So this suggests a prevalence rate of 36% for psychological maltreatment, which is significantly higher than the 6.4% reported by CPS, the U.S. Department of Health and Human Services, which is the source of the child maltreatment reports. So Hart et al. Describes why this is the case. One of the reasons why psychological maltreatment is not readily defined and identified is due to statutes defining emotional abuse as emotional harm or mental injury, which focuses on what? The indicators of harm rather than exposures to acts of maltreatment. In other words, either the likely to cause harm, exposure to acts of maltreatment, likely to cause harm, or has caused harm. The same holds true when professionals utilize the resist-refuse dynamics model to identify parental alienation, because some cases of parental alienation, child abuse, occur in the absence of a child resisting or rejecting contact. And that's primarily what we're going to look at today. So what's the result? Failure to identify cases of psychological maltreatment and parental alienation when we don't have the right operational definition that has to account for acts of maltreatment before they hurt the child. We don't wait till they hurt the child and then say, oh, the child's hurt. Now we're going to do something about it. Sometimes it's too late. So Burnett talks about the prevalence rate in the 2020 parental alienation science law. Among high conflict custody cases, roughly 20% involve some degree of parental alienation, which he's talking about likely to cause harm exposure to parental alienation behaviors, based on studies from Baker, Burns, Bowe et al., and Kopetsky. Estimated prevalence, parental alienation is believed to affect approximately 0.5% of the 74 million children in the United States, which equals roughly 370,000 children and adolescents. So I want to take a quick look at how Dr. Gardner differentiated between parental alienation and parental alienation syndrome. And you can just use PAS as parental alienation symptoms if you don't like the word syndrome. Quote, there are many causes of parental alienation, for example, physical abuse, emotional abuse, verbal abuse, sexual abuse, and neglect. But there's another reason why children can become alienated from a parent, namely being programmed into a campaign of denigration by an alienating parent. The disorder so produced, which I call, this is Dr. Gardner talking, parental alienation syndrome, is also a form of parental alienation. In short, the parental alienation syndrome is one subtype of parental alienation. What does that mean? It means that parental alienation syndrome is here and parental alienation is here. So parental alienation syndrome is subsumed within the gambit of what all we would call parental alienation. Most researchers miss this, or they misreport it or misapply it to cases. And we're going to show you why and how. So how are experts and judges dealing with parental alienation? Okay. Psychological maltreatment. Inside of that gambit, we have parental alienation. And inside of parental alienation, we have parental alienation symptoms. And of course, the 5-factor model. So with the understanding that parental alienation is a form of psychological maltreatment and the cluster of parental alienation symptoms is but one type of parental alienation, I've worked on 370 cases where parental alienation symptoms were alleged. 30% were not found. So 30% of the cases that I was hired to find parental alienation, I didn't find it. That represents 111 cases. 70% parental alienation was found without resist refuse factor. So there was no resistance or avoidance or rejection of the targeted parent, but there was parental alienation found. And 50% of the parental alienation found cases had a resist refuse factor, which is 5-factor model factor 1, and significant parental alienation symptoms, which is the 5-factor model factor 5. So then my research team and I looked at Michigan appellate cases, and you can do this, and I can share with you this data, and you can look it up for yourself and read these opinions. 58 cases we pulled and we queried on Westlaw parental alienation, unquote. That simple, okay? So we wanted to find out how trial courts and the appellate courts were discussing and dealing with parental alienation. So 60% parental alienation was not found. Let me say that again, because there's a lot of misinformation out there in the scientific literature by detractors and deniers of parental alienation. This is the case law. Appellate judges and trial court judges in Michigan from 1996 to 2024, 60% where parental alienation was alleged was not found, meaning they ruled it out. They said it's not happening. 40% found, 40% of the cases, there are 23 of the 58 cases, were found to have parental alienation without the resist-refuse dynamic, which means it's in the red circle, not the yellow circle. And then, of course, this is what they found. And this is why I did this research, because I wanted to find out if we're missing something, if we're getting it wrong, if we're getting it right. And if we are, let's learn and help the judges figure it out. And more importantly, the experts. So 61% of the parental alienation found cases had a resist-refuse factor and parental alienation symptoms. So what does it tell us? How are judges dealing with PA? Parental alienation, at least in Michigan. Judges are finding parental alienation in 40% of the time it is alleged. In 61% of the cases where a judge has found parental alienation, they have also found a cluster of parental alienation symptoms, including a resist-refuse dynamic. Excuse me. Judges are ruling out parental alienation 60% of the time it's alleged. Now let's look at the gender statistics. A lot of misinformation about this. So, and I got my little note. Note about custody allocation, 80% to mothers, 20% to fathers, according to the U.S. Census Bureau, 2018. So let's take a really close look and drill down on what this means. 44 mothers were accused by the fathers of parental alienation, and only 15 of those mothers were found to be alienators. And 34% of the mothers accused were found to be alienators, while 66% were not. Now let's go to the fathers. 13 of the 58 fathers were accused of parental alienation. 5 of them were found to be alienators, and that means 38% of the fathers accused were found to be alienators, while 62% were not. So there's a slight difference in the statistics here, which tells us that if we had, I mean, this is a theoretical hypothesis, that if we had more fathers having custody, that gender gap, in other words, more mothers accused of alienation and less fathers, but with respect to what's found by the court and what's ruled out, it's pretty equal. 66%, in fact, less were ruled out when it comes to fathers. So it suggests that fathers, when given the opportunity, are just as much alienators, if not more, than mothers. It's a really important finding. And if you drill down on this, you have to kind of wade through, the mist and the fog of the willfully ignorant to get to these statistics. So let's take a look at one of the most recent cases, because it's instructive. We're doing an autopsy on a case here. We're Monday quarterbacking here. Okay, so McMurphy versus Paz is 2024 appellate case that was tried in Oakland County. Father alleged parental alienation and a motion for a change of custody, and the court held 12 evidentiary best interests of the child hearings. That's a lot. Mom's expert, Kelly Champion, testified that ABSEC has never recognized parental alienation by itself as constituting child abuse, unquote, and that, quote, there's no medically accepted definition and procedure for determining whether parental alienation is present, unquote. Although Mom's expert acknowledged concerns that the minor children had been coached to make sexual assault allegations against the father, she opined that it's rare for a child to give a report that is coached. It's rare, maybe in her world, but not in the world of parental alienation. CPS investigated the allegations, did not substantiate. The forensic interviewer noted in a report concerns that mom was coaching the minor child during the interview, unquote. So let's continue. Father's expert, Robert Evans, testified parental alienation occurs when a child rejects a parent without justification on account of the other parent's influence, unquote. Dr. Evans provided a 5-factor model to identify when parental alienation exists and testified that, quote, all 5 factors must be present for alienation to be occurring, unquote. Trial court found that the father failed to meet his burden of proving that parental alienation existed because he failed to connect the evidence pertaining to mother's actions to a negative impact on their minor child. So the false allegations of sexual abuse and some of the other things, which got real ugly, didn't constitute what the court felt, at least rightly or wrongly, constituted meeting his burden for clear and convincing evidence to show that the change of circumstances was warranted to reverse custody. So the trial court further noted that the primary reason for the father believed that custody should be altered is that the mother had engaged in alienating behavior, but found that the father engaged in the same tactics himself. Well, same tactics, they were both somewhat alienating behaviors, but making false allegations of sexual abuse is a lot different than other forms of alienating behaviors. So let's take a look at what happened. Did mom's expert, this is our analysis, we're just going to think out loud. Did mom's expert help the court understand how parental alienation is a form of corrupting, exploiting psychological maltreatment within the definitions provided by ABSEC, which is the Association of Professionals Society on the Abuse of Children. It's the American Professional Society on the Abuse of Children. No. Why? Because ABSEC describes corrupting, exploiting psychological maltreatment as, quote, caregiver acts that encourage the child to develop inappropriate behaviors and, quote, restricting, interfering with, or directly undermining the child's important relationships. We can make that connection. Why didn't she? Did dad's expert help the court understand how to identify parental alienation as a form of child abuse independent of harm impact analysis? No. Why? Because he said parental alienation can only be diagnosed when all 5 factors are present, which includes a resist, refuse factor, and a factor that requires the exhibiting of some, many, or all parental alienation symptoms. What does the science say? Parental alienation child abuse can be diagnosed when exposure to parental alienation behaviors is likely to cause parental alienation symptoms, regardless if those symptoms are present. I'm just going to let that sink in for a second, because that's what this whole presentation is about. So what PA science, parental alienation science, was misrepresented? Well, we know that parental alienation strategies are likely to cause harm because they involve several forms of psychological maltreatment recognized by social science research: exploiting, terrorizing, isolating. It's in the handbook. You know, American Professional Society on the Abuse of Children. Here's what they say. Caregiver acts that are corrupting and exploiting, modeling, permitting, or encouraging, betraying the trust, being cruel to another person. That's directly correlated with the parental alienation strategies of bad-mouthing and telling the child that the targeted parent does not love him or her. There you go. There's the connection. Here's another one. Restricting and interfering with the child's relationships. It's directly correlated with strategies of limiting contact, interfering with communication, interfering with symbolic communication. Modeling, permitting, or encouraging developmentally inappropriate behavior, parentification, adultification, infantilization, living the parent's dream. This behavior, this exploiting, corrupting behavior, is directly correlated with the parental alienation strategies of forcing the child to reject the targeted parent, asking the child to spy on the targeted parent, and asking the child to keep secrets from the targeted parent, and cultivating dependency, undermining the authority of the targeted parent. It's all correlated. That's what we're talking about. Corrupting emotional, psychological maltreatment. ABSEC is saying it. There's a connection there. There's a correlation there. So, next one, coercing the child's submission through over-involvement, intrusiveness, which the DSM calls overprotectiveness, dominance, allowing little or no opportunity or support for the child's views, feelings and wishes for alienated children, when it's the wishes of the alienating parent that are paramount and are dominating. The child's real views are hidden. They're occluded from the alienated parent. Why? Because they don't want to ruffle any feathers, like Rod told us in his presentation. So, and it talks about a double bind in here too, which is the child is doomed to fail or disappoint, or disorientating the child by stating something is true or false when it is patently not, which we saw in all the false allegations of sexual abuse cases that involve alienating behaviors. This exploiting, corrupting behavior is directly correlated with the parental alienation strategies of withdrawal of love, telling the child that the targeted parent is dangerous when they're not, and forcing the child to choose. In other words, trying to resolve a loyalty conflict by over-enmeshment with a pathological enmeshment with the alienating parent and a rejection, an unjustified, unwarranted rejection of the other parent, which then turns into parental alienation symptoms. Terrorizing emotional abuse. These include threatening to abandon or abandoning the child. That's at a psychological level we're talking about. Not just I'm going to leave you physically. I'm going to abandon. I'm not going to love you anymore if you don't hate your mom or hate your dad. This terrorizing abuse is directly correlated with the parental alienation strategy of withdrawal of love. So here's the connections. You can take my research and just put it on their desk and say, you know, I kind of think this is worth looking at, Mr. Legislator, Miss Judge, and so forth. Terrorizing, setting rigid or unrealistic expectations with threat of loss, harm, or danger if they're not met. This is directly correlated, again, with withdrawal of love, forcing the child to choose, and forcing the child to reject the parent. Placing the child in a loyalty conflict by making the child unnecessarily choose to have a relationship with one parent or the other, This is in the handbook. So this Dr. Champion said it doesn't exist, said it's not there. So what is this correlated with? Forcing the child to choose, forcing the child to reject the parent. That's what we're talking about. Isolating abuse, we're very familiar with this. Confining or placing a child, unreasonable limitations to their freedom. Isolating behavior is directly correlated with limiting contact. In some of these cases of alienation, you'll see where there's a refusal to allow contact, which goes on for months and sometimes years, and it becomes this rock of a status quo that becomes immovable. Placing unreasonable limitations or restrictions on social interaction with family members or peers. This isolating behavior is directly correlated with the parental alienation strategy of limiting contact, of course. Okay, so what parental alienation science was misapplied in McMurphy versus Paz? Well, we know that the 5-factor model helps identify parental alienation when it has advanced to the stage where a child is resisting or refusing contact. Okay, that's in the literature. And we also know that parental alienation is diagnosed in cases where a child's exposure to parental alienation behaviors is likely to cause parental alienation symptoms, even if they're not there and if they haven't developed yet. And that's in Edward Crook's article in 2018. It's also in Dr. Richard Gardner's article in 2002. Dwylene, how are we doing on time?
We're doing good.
Okay.
We have about 20 minutes. We have about 20 more minutes or so.
Oh, all right. I'll slow down because sometimes I have a tendency to talk too fast.
And that's okay too. We can take a break early after you're done.
Okay. So how are judges dealing with PA? Let's continue. This is a terrible case. It goes back to 1999. I picked it out of the 58 cases that we talked about simply so we could have some sort of understanding of how the statistics that Psych Law kept, which I was personally involved with, how there's some difference there in terms of, are we missing cases? Are we ruling out cases that are parental alienation? And are we waiting to rule in parental alienation because we think that we have to have a resist-refuse dynamic and it has to check off all these criterion boxes? And, I'm saying no, because that's what the literature says. It's child abuse, and when a child's exposed to child abuse, you stop it. You do something to effectuate change. Okay, here's Krieger versus Krieger. Plaintiff father alleged parental alienation and a motion for a change of custody. Dad relied on the friend of the court evaluator assessment that the defendant mother, quote, consciously alienated and brainwashed the children against the father, and that dad should be awarded full custody of the children with limited visitation for mom. Defendant mother's expert prepared a report and concluded that mom was not engaging in parental alienation, that mom should be awarded custody of the 4 children, and that the problems between the children and the dad were the result of dad's own neglect and abuse, and dad being schizophrenic, paranoid, delusional, and psychotic. Well, that's a whole bunch of heap and diagnoses. Here we go. Here's what happened. The trial court awarded joint legal and sole custody to mom based on the recommendation of mom's expert. However, the Court of Appeals noted that the mother had for some time severely alienated the children from their father and inappropriately involved the children in conflicts that should have been confined to the parties alone. And so that's, confiding in the child. That's a parental alienation strategy, as identified by Baker and Darnell in 2006. The testimony was clear from the oldest 3 children that expressed alarmingly and strictly negative views of the father and the father's family, while noting that the mother had virtually no negative qualities. So for us, we all know what that symptom is. That's a parental alienation symptom called lack of ambivalence, which is a fancy way of describing splitting, which is a primitive psychological defense that can be very harmful if it develops long enough. It can be deadly to kids because they have a very distorted view of reality, and they are not able to recognize the reality of their own object relations, which is, how do I think of mom and how do I think of dad, my parents, and does it comport with reality? And if it doesn't, which is how these cases work, when you have, mom is all good or dad is all bad, or dad is all good and mom is all bad, and when it's not the case, then you have a lack of ambivalence. There was also substantial evidence that the children deliberately and apparently with defendant mother's tacit and express approval sabotaged the father's visitation time by acting up, challenging and disrespecting him, and otherwise causing problems. These are, clearly signs of alienation. At least it appears so. So let's continue. 3 of the professionals involved with this family testified that the father had a history of passivity and acquiescing to the mother that was what they called problematic and had to be improved, while noting that the mother's conduct was conscious and egregious. So here they're making commentary and holding it against a targeted father who's passive and acquiescing as if it's causing harm to the children and making excuses for the mother's conduct. That's what it sounds like, but let's continue. Finally, the Court of Appeals remanded the case, directing the trial court to require, as a condition of custody to mom, that the parties and children receive ongoing counseling with a therapist. There you go. We're just going to throw everybody to a therapist and magically it's going to get better. The kids are not going to be alienated. Doesn't work. Who has experience in parental alienation. And this is the Court of Appeals not disturbing the lower court's findings as to credibility and to the witnesses, but saying, hey, we're going to remand this and make you as a condition of custody because we think there's a problem here. There's alienation going on. And that's kind of what they're saying. So who has experience in parental alienation, and the father's parenting time should be adequate to facilitate the repair of his relationship with the children consistent with the party's counseling. And so that's kind of code word in Michigan, means parenting time in our statutes is a frequency, duration, and type reasonably calculated to promote a strong bond. So what would that look like? I don't know. I don't have that case file to follow up, but I think it's important that we do follow up on these cases and keep track. So we learn from our mistakes and we learn from our successes, because we're all fallible and we all make mistakes. And what we're trying to do is protect and help children and help families deal with these serious situations. So let's take analysis. Let's put our analytic cap on here. Did mom's expert help the court understand how PA was present? No. Why? Because the expert appears to have relied on evidence of the father's psychological deficits that may have been impairing his ability to recognize reality, schizophrenia if he really has it, while not giving enough weight to the mother's alienating conduct or the children's parental alienation symptoms. At least that's what it looks like. You can read that case and go find it, and you may have a different opinion, but that's what it looks like to me. Did dad's expert help the court understand how to identify parental alienation in this case? Yes. However, it appears that the trial court did not afford much weight to what the Court of Appeals called substantial evidence of parental alienation behaviors by mom and parental alienation and symptoms exhibited by the children. Instead, 2 things against the father seem to be articulated in the opinion. 1, mother had a warmer, closer relationship with the children and they expressed a preference for her. That's literally what they stated. And 2, father is to blame for allowing it to occur the last 4 years. That's a direct quote. So they're blaming the targeted parent for allowing it to occur because he's delusional or psychotic or schizophrenic, or maybe so. I don't know. I mean, the major question is, does he have the ability to parent his children given some of his psychological deficits? I don't think that question was answered. But I think, there was a conflict because the friend of the court did find that the mother was alienating. And so there was a disagreement, and the court in its own analysis ended up, how this case lives. Was parental alienation properly ruled out? Well, let's take a look. We know that targeted parents often are more passive and acquiescent compared to alienating parents. That's what the literature suggests. And I've kind of confirmed that over the years that I've worked, 10 years, 11 years I've been doing this. We also know that when parental alienation behaviors by a parent are severe and chronic enough to induce the parental alienation symptom of splitting, which is the lack of ambivalence as it is in this case, we call parental alienation and make the necessary adjustments to custody and access to protect the children from parental alienation child abuse and to repair the damage that's done, reversing the alienation, which is deprogramming. And that means lots of parenting time with the alienated parent if it's safe to do so. And we don't know because we're just looking at this case from afar. The kind of counseling ordered by the Court of Appeals in this case has been shown to be ineffective as long as the children reside in the primary custody and control of the alienated parent. And that's from Warshak's article in 2015. So, how much time do we have? Dwayne? Are you there? Seems like we have some questions here. Okay, so how should we deal with the problem? Okay, I suggest that we have ongoing continuing education and continuing legal education training for all legal and mental health professionals that work with families that are in conflict or in crisis, and that the focus of this kind of training should be on identifying parental alienation as child abuse when there's evidence of exposure to parental alienation behaviors with or without the presence of any resist, refuse dynamics. It should also focus on analyzing cases like we just did to learn what works and what does not work so we can make adjustments and learn from our mistakes and help families who are in need. Should also focus on understanding how programming and brainwashing work and affect children's ability to recognize reality. So brainwashing is very, very misunderstood and under reported in the literature. There's a gap. It's not talked about very much in the literature. The only real significant treatise on brainwashing and programming children and how it affects them is from Dr. Stanley Claywar and Brian Rivlin, which they did initially was a 12-year study from 1978 and published in 1999 or 1991 by the American Bar Association, called Children Held Hostage, Dealing with Programmed and Brainwashed Children. And it was a pretty small book, but really packed with lots of information. They have a whole chapter on brainwashing techniques that they saw and experienced with high conflict families, and they had roughly 700 families in their initial 12 years that they worked, and with this kind of dynamic. Then in 2013, they updated it and added another 300 cases, so up to 1,000 families as their sample, talking about brainwashing and dealing with it. And they added more material. So now it's 556 pages. It's a fantastic book. It's a really good, I consider it like the Bible of understanding parental alienation, the programming and brainwashing aspect of parental alienation. And I think there isn't much else out there about brainwashing. It's in the scientific community, there's certain terms that lack. It's assumed that we know what something means when we say brainwashing, but I don't think we do. And why it's important to train professionals is we really need to have, and you'll see this codified in statute, what we call operational definitions. So I showed you the Michigan statute for serious mental harm and, of course, second-degree child abuse, and it defines how we're going to use these terms. And we really need to know that, and we really need to put that in the hands of the folks that we're going to be helping when it comes to identifying parental alienation as a form of child abuse. So I want to just recap a little bit before we go to our question and answer. So confronting misinformation. Okay, this is the last component of what we should do. There's a lot of misinformation and disinformation about parental alienation that's out there. I have other presentations and other workshops that deal with that because it's kind of a whole ball of goo. It's just a lot of junk science and junk scientists who promote really horrible, unscientific constructs that dilute and wash away and take our eyes off of what we're trying to look at. And so I think it's important for us to be grounded in the research of what constitutes psychological maltreatment with the pictures that I showed you. In other words, we have this big circle, which we call psychological maltreatment. And just inside there, we have parental alienation. And that means exposure to any corrupting, exploiting, terrorizing, isolating behaviors that are likely to cause a child to develop parental alienation symptoms. That's parental alienation. That's the big ball in the middle of psychological maltreatment. And then the next one we want to look at is the one inside there, which Dr. Gardner said was a subtype. That's the parental alienation symptoms. When you have the rejection, the refuse, and the campaign of denigration, because the campaign of denigration, not always, but most often starts with the alienating parent. And once they develop this sick relationship, this pathologically enmeshed relationship, then you have the borrowed scenarios, the reflexive support for the alienator, and the independent thinker phenomenon. And once the campaign of denigration, one of the things that's not talked about very much in the literature is the link between what constitutes lack of ambivalence and why a child would develop a lack of ambivalence. We could say, okay, it seems like that's there. But when you really drill down, it starts as children learn from models. In other words, a parent models for them how to deal with life and how to deal with emotional anxiety and that kind of thing. And when you see a parent, an alienating parent, dislike, hate, and revile the other parent for frivolous reasons, or manufactured reasons, or exaggerated reasons, that becomes an internal working model for the child. And that's why we call it corrupting emotional abuse. And then this is a secondary abstraction. When a good person, self-concept, I'm a good person, I'm this child who's being alienated, only bad people hate people that didn't do anything wrong. And so that's your internal working model, because that's the morals of society. But with the alienation process, and why it's so corrupting and brainwashing, is that converts into, well, I have to deceive myself into thinking that person did wrong, so I'm not a bad person for hating them. That's the program. That's the program. A lot of mental health professionals, legal professionals, and even judges don't understand that, because it walks and talks differently. And then you have the disinformation folks who say it must be this. Mom was smoking cigarettes. She ran off with the gardener, so that's why the kids hate her. Dad's not an alienator. We should honor whatever the kid wants, without making a diminished capacity assessment of whether or not this child is speaking from their own personal knowledge. And if they are exhibiting a lack of ambivalence, can we recognize it? Do we understand what that means? And can we help them so that they don't develop this inaccurate appraisal of self and self-deception, which is really the hallmark of an alienating parent? It's that self-deception, because they're the ones that become the splitters, the ones that split internally, and because it's the way they cope. And that's why we call it a primitive defense mechanism, because it staves off anxiety. If somebody else is to blame for the problems that I'm experiencing, then it's easier for me to deal with them. So getting the resources to scaffold parents in this state of crisis, like Rod said, getting them to get along. You know, sometimes in mild cases of parental alienation, you can have a family therapeutic model where you have the alienating parent and the targeted parent together, and the kids out of the conflict, completely out of the middle. And you have them work on with a therapist who can, and it's court ordered and enforced. Sometimes that works. And sometimes you can remediate that, especially if you can teach the parents to sort of act. And this is the hard thing to do as a family therapist, to role play what they would do if they were together and they had to survive. If they're out in the prairie and it was just the two of them and they had to get along, they would, there's a, calculus of how much blame sharing are we going to take? We're going to cover each other's weaknesses and play to each other's strengths. So if I'm the stronger one of the pair, of a pair bond between two divorced couples, former marital partners, then during the marriage, it seems like 80% of the conflict would be shouldered by the stronger of the two and the 20% by the weaker of the two. But when they separate and they're in conflict, they don't have that support anymore. So then they turn to the kids. And that's really some of the, the back data for how you deconstruct these and help parents understand this in a face-saving way, so that alienating parents can, get back on the page that they need to be on to be safe with their kids. So I think are we at question and answer time, Dweiling?
Yes, we're at the question and answer portion.
Okay, do we have any questions, burning ideas, thoughts, comments? I talked too fast, talked too slow. I didn't shave well enough, anything like that?
I think most of the guests are muted. They have to unmute themselves if they're going to ask a question. Or if you want to check in your chat box, a lot of them were asking the name of your handbook.
Okay, so the handbook that Dr. Larandos, who was the founder for Psych Law before I bought it out, it's called Parental Alienation, Science and Law. It's published by Charles C. Thomas, and I can hold it up for you. Hold on a sec. Let me grab it. That's what it looks like. It's pretty thick, but it's good reading. It's in digital format too. You can get it on Amazon. There's also, I would recommend, like I said, Dr. Stanley Claywire, Environmental Evelyn's book, Children Held Hostage. I think that's a must.
Perfect. If anybody has any questions, you can put them in the chat, or you can unmute and ask.
Oh, here we go. I see one. Most therapists refuse to recognize PA. They're not trained. Best interest not considered. I'm not sure how we can change this. Well, I think it's a big ask. I think it's very difficult. I do yearly training for free for some of the family therapists in this area, and I think it has a trickle-down effect. I mean, you plant seeds. I think we're in the business of planting seeds, and if you're carrying the torch for kids, I think you want to do that. Just plant the seeds and get the information and put it in the hands of people.
Okay, if nobody else has any questions, I'm going to check on the chat really quick.
I have a question.
Yeah.
In the family law profession, say you're going in for a modification of a case, and the severe parent alienation has already now gone to kids that are resisting and refusing contact. And so you've got other kids that are coming up the line. And it's so you've got kids that are no longer in contact with the other parent. It's all one parent's all good, one parent's all bad. And so you were saying that the way that sometimes parent alienation counseling is not as effective, and you've got to get that possession back to the other parent. So that's where the courts come in, and you're going to have to maybe do a child custody evaluator or social study, and then and then what if there's not funds for an expert, and you're trying to. It's just very difficult getting the kids back into that possession or time with the other parent, and then they get older and they're teenagers. So it's a hard case when it's already at that point, right?
Yes, I run into that all the time, and so it's really a lot of these cases sit that way when they come to me, and sometimes we can do things and sometimes we can't for the very same reasons that you're just articulating. But I have a big success case in Florida, and it just so happened that the judge stood up and listened, and the lawyers said, well, this judge doesn't believe in parental alienation. And I said, I don't care. I said, you're talking to the record. You're not talking to the judge, because that's what counts. You're making a record. And so we made the record, and guess what? The judge said, if parental alienation is going on, there's going to be hell to pay. And then bam, he made the action that needed to take place. And those kids were turned around, 2 15 and 16-year-old daughters who were severely alienated. I hate you. I don't want to talk to you. Won't go to school. Nothing. Running away, calling the police. And all of a sudden, I love you, Dad. I'm so glad. And,
oh my gosh.
And it had another case like that in Texas, where the dad had 2 boys that were right at that cusp of turning to adults, and turned it around. And then he actually, more than the mental health professional, he's the one who facilitated a positive relationship again after he was given access. And this was conservatorship, I guess, Texas. So,
Jeff, I see you have a question. Jeff Golden.
Yes. I have a question for Dr. Wygant. You mentioned at the beginning that you are an alienated father, and I'm wondering, how do you do your work? Doesn't the parent who's accused of being the alienator reject you as an evaluator?
Oh yeah, they do it all the time, but that's my superpower, as my wife says. Yeah, they come after me all the time. They try to make complaints against my license and stuff. It goes nowhere. I'm here because every time you stop, this from happening and help a kid, it makes me feel good. So I feel better.
Excellent. Go ahead, Paula.
Hi. My question is specific to when children are severely disrupting the parenting time, limited parenting time, because there is resist, refuse dynamics going on. But there's still ambivalence. So still spontaneously being able to say what they really love or like about the parent, but at the same time, this sort of abhorrent behavior and disruption when they're with the parent. I am just wondering, therapeutically, if you have recommended therapeutic interventions in working with the entire family system in that situation.
Great question, because it's something that comes up all the time. 2 things need to happen, and I say this. Therapeutic, the best therapy, they say sunlight is the greatest disinfectant. So the sunlight of truth has to happen in an organic setting where you have lots of access, lots of time. And you have to go forward in time with parents who I'm coaching, targeted parents, and say, look, the past has to go in the rearview mirror. You have to wash that out of the kids naturally in a face-saving way. That has to happen. So you have to have an abundance of time. That's really the therapy. Therapy, like sitting in front of a mental health professional and talking about your problems or anything, that has only value to support, scaffolding, parenting questions, and getting the kids to be able to critically think, and being able to do, maybe role playing, and getting the children to kind of have their own sense, and the acting out behaviors that you're observing, they're able to have those in a safe space. And a safe space means not like going to your safe space and going and crying PTSD. No, no, no. A safe space means being in the arms and care of the targeted parent in a very natural setting where they can laugh and watch a movie together, and they can cry and yell and scream if they have to. But they have to know that they can let out their feelings, because the louder they are and the stronger their feelings, usually the stronger the original attachment.
Mm.
And at least that's what I've observed.
Well, thank you. Could I just ask one follow-up to that?
Mm-hmm.
When there's multiple children, same scenario, when there's multiple children who are feeding on each other in that dynamic, do you recommend maintaining contact consistently as a sibling group, or would you recommend some time with one or more children in various combinations with the parent?
Well, if parenting time is limited and you're cramming 2 or 3 kids in and say, well, now you have 90 minutes to spend with your mommy or your daddy, and it's going to be supervised in a professional setting, that's a destruction. That's hurting the kids. Unless you have to do it for safety's sake. I mean, if there's some safety concern, fine. But if there's no safety concerns, that tends to go away. Again, significance of time. You change the plan from, let's say, every other Thursday, Friday, Saturday to 2 weeks on, 2 weeks off. Now you're sitting with the targeted parent for 2 weeks and you got 4 kids. There's going to be stuff to do, and you're going to give individual time. And then the targeted parent has to make whatever sacrifices in their profession so they can attend to them individually in time. You need a quantity of time sufficient to reasonably calculated to promote that bond and take care of them individually. So you want both. You want the togetherness of the siblings, and even if they're bouncing off each other, you want to work with them individually as well. And then, of course, with a parenting coach, if you will, and a family therapist to sort of as adjunct intensive care.
That's perfect. Thank you so much for all of your information.
Okay.
We very much appreciate it.